So welcome to today's webinar on dealing with sexual harassment complaints in the workplace. As I mentioned, my name is Carly. I'm from Community Legal Centres Queensland, and shortly I'll be passing over to Rachel Drew, who's a partner at Holding Redlick, for her presentation. Before we do that though, I would like to acknowledge the traditional owners of the land on which we're holding this webinar today. In Brisbane, they are the Turrbal and the Yagara people. I wish to pay my respects to their elders, past, present and emerging, and acknowledge the important role that Aboriginal and Torres Strait Islander people continue to play in our society. As this webinar is being viewed by people throughout Queensland and a few people interstate as well, I'd like to also pay my respects to the traditional owners of the land throughout the country and welcome any First Australians who have tuned in to listen today. So this webinar is going to be recorded, and we've put the PowerPoints up in the handout section of the GoToWebinar control panel. I've also emailed them out this morning to anyone who registered by about 9:15 this morning. If you didn't have a chance to grab those though, you can download them from the GoToWebinar software. Today we've got, a little bit of a difficult topic, but one that's very important for community legal centres to be aware of in managing their staff and, ensuring they're meeting their obligations as an employer. As we know, there has been a lot of high-profile sexual harassment scandals working their way around the media and through particularly the entertainment sector. So Rachel is going to talk to us today about how best to handle sexual harassment issues and complaints arising from workplaces. And she's going to give us a little bit of an overview of what sexual harassment is, including the legal definitions, the elements of employer liability, and also what to do if you receive a complaint of sexual harassment. Rachel will then sum up by talking about victims' rights under the law and remedies available, and of course how to prevent unacceptable behaviour in the workplace. Just also keep in mind obviously the nature of today's topic is can be distressful for some people. If you do feel that you need to absent yourself from the webinar at any time, of course that you're more than welcome to do that. And if you need any referrals for yourself or for others in your workplace, please have a look at the Keep Safe section of our website with some helpful links and information on there. So I think that might be everything from me. We'll take questions at the end, and if you do have any questions that come up for you during the course of the webinar, please feel free to type those into the question box. Similarly, if you have any technical issues, please type those into the question box as well, or better yet, because Rachel's here with me today and we're sharing a laptop, you can feel free to email them through to me and I'll keep an eye on my emails as we go through the presentation. So without further ado, I'll pass over to Rachel now, and you'll hear from me again closer to the end of this session. Thanks so much, Rachel.
Morning, everyone. As Carly said, I'm a partner at Holding Redlick. I'm a workplace lawyer. I've been a workplace lawyer for almost 20 years now, and I've done a lot of workplace investigations in that time. And in fact, most of my workplace investigations have involved some element of sexual harassment in the workplace. So I've spent a lot of time looking at this issue from the perspective of an employer and also looking at the issue from the perspective of an investigator trying to make some decisions in relation to how to deal with a sexual harassment allegation. I am going to try to stop talking by 10 to 11. So that we've got plenty of time to answer all of the questions that you have at the end. There's quite a lot of content in the PowerPoint. Some of them are lists which I might be able to move through reasonably quickly, but please, you're very welcome to ask any questions you like and we'll make sure we answer all of those. Just to give this some context, the 2017 Time Magazine Person of the Year honours workers who have made public statements about workplace sexual harassment. So the cover of Time magazine includes Ashley Judd, who was one of the first actors to make allegations against Harvey Weinstein. Taylor Swift, the tall woman standing up, is a corporate general manager who was sexually harassed by one of her directors. The other ladies are retail hospitality workers, and the elbow in the corner is an anonymous hospital worker from Texas who raised her sexual harassment workplace complaints on the condition of anonymity. So that's the significance that sexual harassment in the workplace has in the current environment, and it reflects the level of prominence of sexual harassment issues and also the level of interest that media now takes in sexual harassment. Sexual harassment's probably always been a pretty interesting topic for media because it does tend to include some fairly scandalous details that media like to put on headlines, but that's the prominence that it's come to now. A lot of it relates to the MeToo movement. So Alyssa Milano was the instigator of the MeToo hashtag last year. Just to give you an idea of the scope and spread of the sentiments in relation to the broad scope of sexual harassment in the workplace. The hashtag had been used 200,000 times by the end of that day, 500,000 times by the 16th of October, and then millions and millions of people referencing it over the first 24 hours. So there's a lot of information. So a lot of people who've used the hashtag have used it to describe their own personal experiences of sexual assault, often in a domestic violence context. But the original motivation for the hashtag MeToo movement was around sexual harassment in the workplace, particularly in the movie industry, but in sexual harassment in workplaces generally. In Australia, there are lots and lots of statistics about sexual harassment in the workplace. And in fact, you'd be surprised when you start to look for some statistics about the number of people who have raised complaints or who report being subject to sexual harassment in the workplace. It's a very, very high number. So 24% of all complaints to the Australian Human Rights Commission involve sexual harassment as an element of the complaint. That's quite a high percentage given the range of types of discrimination that the Australian Human Rights Commission looks after. There's a statistic which the Australian Human Rights Commission has released in 2012. 25% of female workers, around 15% of male workers reported some form of sexual harassment in the 5 years before that survey. The Human Rights Commission is repeating that survey right now, and I can guarantee the results of that survey are going to get a lot of media interest. So I've put the link there to their latest media release, but there will be more, and to be honest, you won't be able to miss it, I suspect. There are some ABS, Australian Bureau of Statistics, reports which suggest that about half the workforce, about half the Australian workforce has experienced some form of sexual harassment over the course of their working life, which is quite an alarming statistic, given the laws that we've had around sexual harassment have been in place for some time. I think a lot of that reporting and a lot of those statistics represent the level of hesitation that workers have in coming forward to make a complaint about sexual harassment. Okay, what are we going to try and cover today? I'm going to talk about 3 cases. I've chosen 2 very recent cases, and then I've chosen a slightly older case, the David Jones case, which you're probably aware of in one way or another. There's just one aspect of that David Jones case that I'm particularly interested in for today. We'll talk about the legal definitions of sexual harassment and the options for a victim if you're advising someone who brings a complaint of sexual harassment to you for help. We'll talk about employer liability. So that's obviously relevant when you're advising someone who has brought an allegation to you to have a look at what the employer has done in the business, but also if you are ever in the position of needing to help your own community legal centre or needing to help your own employer or an employer client, to know what those elements are, and then how to manage a sexual harassment complaint in the workforce. Look, there's no one way to do that, but I'll sort of talk about some big picture principles that you can apply if you're in the position of needing to do something. These are my 3 cases. I've included that slide just to give you all of the citations. The first one involves a group of cleaners and a groundsman at a school in Queensland. So this one was decided last year. The factual background is that there was a rumour at the school that 2 of the senior staff members within the school were having an affair, that they were otherwise married but having an affair. There was some amount of banter between the groundsman and 2 of the cleaning staff in relation to that affair, and the cleaning supervisor and the groundsman decided to set up a classroom to make it look like someone had been having sex there. The cleaning supervisor directed the cleaner to clean up the mess. The cleaner thought that he was cleaning up bodily fluids. He was very, very distressed by that, and he suffered quite a serious stress injury as a result. It was interesting, the stress injury itself, although he was very stressed about having to clean up the bodily fluids, what he thought were bodily fluids, the point at which his injury crystallised was at the point that the cleaning supervisor admitted to him that it was just a prank, that the cleaning supervisor and the groundsman had set up the scene to catch him. So the question for the Queensland Civil and Administrative Tribunal, which is where workplace sexual harassment complaints used to go, they don't go there anymore, I'll talk about that a little bit later, there needed to be, the tribunal needed to answer the question of whether or not this was sexual harassment directed to the cleaner. And it's an unusual factual scenario because it's not sexual comments being made to him. It wasn't anyone touching him or showing him pornographic pictures. It was these background discussions about the affair, possible affair between the staff members, and then a scene set up as though somebody had been having sex in the classroom. The tribunal considered it and decided that because it was directed to this cleaner, that the conduct was in fact in relation to him and it did amount to sexual harassment. He was awarded an amount of money, which is a pretty decent amount of money. $70,000 for non-financial loss is a pretty hard figure to get out of a court or tribunal these days. So that's it's high and intentionally high to reflect the nature of the conduct by the workers. In fact, in the case, when you're dealing with more than one defendant, so the cleaner sued the State of Queensland, his employer, and he also sued the cleaning supervisor personally. The tribunal was so alarmed by the conduct of the cleaning supervisor in, being in cahoots with the groundsman and setting this up and directing the cleaner to clean it up, that the tribunal said, while all parties are liable to pay the whole of the amount to the cleaner, the tribunal directed that the cleaning supervisor pay half of that if the state wanted to chase the supervisor, the state would be entitled to recover half of that from the supervisor. That making that sort of order is quite significant, and it reflects the view that the tribunal took of the very negative view it took of that cleaning supervisor in conducting himself in that way. So the Fraser-Kirk and David Jones case, it's a few years old now, and it was highly sensational at the time. So it's 2010, Federal Court of Australia. That citation relates to a set of directions that was given by the Federal Court for the conduct of the matter. It was mainly just to do with some particulars and some amended defences and things, but it's quite interesting that part of the court's direction included a direction to the parties to stop filing submissions that look like media statements and start filing proper legal submissions on the matters concerned. What I think is probably, so the sexual harassment that was involved here between the CEO and the assistant, Christy Fraser-Kirk, was your sort of, traditional sexual harassment. It was he would unwanted touching her on the leg, on the knees, making sexualised comments to her, suggesting to her that they should have a relationship. Those types of comments and conduct was the nature of her complaints. What was really interesting, so they chose to go through the federal court process, which allowed them to include in their claim a claim that David Jones had breached the Trade Practices Act. Now, there's a new act called the Competition and Consumer Act, which has replaced the Trade Practices Act. But that was a very interesting strategy on behalf of the complainant in that matter, to not just limit herself to the usual Human Rights Commission or Anti-Discrimination Commission and Tribunal outcomes, but to look for a remedy in some of the federal law. Hard to tell. So in terms of her prospects of success on that claim, very hard to tell. And the citation, which relates to the directions that was given by the court, does suggest there was some serious issues as between the parties as to whether or not that claim was going to be successful in these circumstances. But it's an interesting strategic decision that does need to be made right at the start of a sexual harassment allegation. If you're acting on behalf of a complainant, if you want to have access to any of those federal laws, you need to think about your jurisdiction right at the start. Was ultimately successful. She was after $37 million. She got a really significant amount of money of $850,000. I think she gave about half of it away to charity. CEO went on to become the CEO of Just Group, which is Just Jeans and Smiggle. So he's doing okay. You can have a look at their annual report to see how much he's earning at the moment. I'm not going to tell you because it's an obscene amount of money. So that's that one. The next recent one. This one, again, it's a pretty disturbing factual scenario, this one. And you can see the name of the case is STU and JKL. Now, throughout this decision, they have anonymised everything. So it's to do with a hotel chain, and the decision refers to the hotel chain as the hotel management company and the hotel. So they're very, very careful in the decision to anonymise it. And part of the reason for that could be that there were some criminal proceedings, and I'll tell you the factual story of this, and you might decide for yourself whether or not there ought to have been some criminal proceedings. The employee who made the complaint was transferring from another of the chain's hotels. So she was redundant at another hotel. She was offered a position which would require her to move to Brisbane. There was a 2-bedroom apartment that the night caretaker lived in, so that was his accommodation. The hotel chain paid for everything to do with that, from the electricity, absolutely everything. The night caretaker didn't pay any part of it. So the suggestion was made by the hotel management company that this transferring employee be allowed to live in the second bedroom with the night caretaker, until she'd established herself in Brisbane. So to give her somewhere to move to. In theory, this is an excellent and very supportive decision by the hotel management company to assist her, given that she was redundant at their other hotel. Now, what happened to her? She arrived, and the very next morning at 5 a.m, the night caretaker appeared in her bedroom naked, started to touch her, tried to take off her underwear. She sort of came to her senses, I guess, woke up and ran out of the room. So in my opinion, those kinds of factual scenarios could easily amount to a sexual assault. It's certainly a question of sexual harassment in the workplace. But I think that if you're faced with that scenario, if you've got a complainant who comes to you giving you that type of story, in my opinion, the first question is, do you want to make a police complaint, not do you want to make an application for some compensation arising from this? I think that clearly unwanted physical contact of a sexual nature, particularly in circumstances where he sort of presented himself naked at 5 a.m. in the morning, should be a matter for police attention, not just a question of compensation. However, we come to QCAT. The decision doesn't say one way or another, but I suspect the level of anonymity given to both the hotel chain and the complainant suggests that perhaps there was some criminal proceedings which had occurred before the case. The case for QCAT to decide was, given the most unusual nature of the harassment, given he had absolutely no basis, he'd met this woman the day before, no basis to expect that there was any sort of interest on her part in having a sexual relationship with him, given that it was probably an assault, how can the employer, or should the employer, be liable for the conduct of the employee? The tribunal found that the employer was vicariously liable. The whole of the accommodation was being paid for by the employer. Both of the employees were only there directly for the purpose of their employment, and therefore it was within the scope of the employer's liability to be responsible and ensure that no sexual harassment occurred. And it was up to the employer to prove if they had fulfilled all of their requirements in terms of avoiding liability. And the tribunal found that the employer in that case had not fulfilled all of the requirements if they wanted to avoid liability. Again, quite a big damages payout, and I said possibility of more there because there was some extra past economic loss that hadn't been properly particularised for the tribunal member who was making that decision. And she actually says at the end of her decision, the $313,316.10. And if the complainant wants to give some more evidence around her past economic loss, that would increase. I didn't find another judgment, so it may have been that the parties simply agreed on the amount of money that the employer was to pay to her in that case. So those are our three cases. So three very different examples of how sexual harassment can work in the workplace. I'm now going to talk about what the definitions are and talking about how does a victim obtain some redress for harassment. So there's a Queensland system and there's a federal system. The Queensland system is the Anti-Discrimination Act, and those listening in Western Australia and Victoria, you'll have your own version of the state anti-discrimination law. I've put down the bottom, so the pathway in Queensland is the Anti-Discrimination Commission of Queensland first, and then all workplace disputes now go to the Queensland Industrial Relations Commission. So even if your matter has commenced in the Queensland Industrial Relations, the Anti-Discrimination Commission, it automatically goes into the QIRC if it's a workplace matter. There is a federal system as well through the Sex Discrimination Act. It goes to the Australian Human Rights Commission as a preliminary step, and then you go on to the Federal Court and Federal Circuit Court. And as I mentioned before in relation to David Jones, very strategic decision was made by the complainant in that case to go to the federal law rather than accessing her state law, because she wanted to get into those federal court rights. If the decision between using your state anti-discrimination legislation and using the federal, you've got, if you're working, in your own state, you do have the option of going either way. The state-based systems are generally simpler, generally cheaper than the federal system. So if you have a complainant who is the employee of a small business, I think that you would be well and truly better off in the state system simply because of the cost. However, if you've got a complainant who has a very high profile employer who might want to get a little bit more of a, look a bit more at some of those federal court remedies because of the nature of the significance of the employer, then you can have a look at the federal system. But as I say, it is a lot more expensive to go through the federal system, and it's hard for a complainant to do it themselves, whereas most of the state systems, complainants can actually run their own matters. Okay, I'll talk about Queensland, what the difference very quickly between Queensland and federal. There's not a lot. The words are quite different. So Queensland lists unsolicited physical intimacy, unsolicited demand or request for sexual favours, remarks with sexual connotations, unwelcome conduct of a sexual nature, and with either the intention of offending, humiliating or intimidating, or where a reasonable person would anticipate that the other person might be offended, humiliated or intimidated. The concept of the offending, humiliating and intimidating conduct is common to both the state and federal. So the federal uses just a slightly different characterisation of what the conduct is. So it talks about an unwelcome sexual advance or unwelcome request for sexual favours, or unwelcome conduct of a sexual nature in relation to the person harassed, and same reasonable person test or similar reasonable person tests. Reasonable person would have anticipated the possibility that the person would be offended, humiliated or intimidated. So again, that common thread. And look, when you want to generalise what is sexual harassment, usually it's that option B, it's unwelcome conduct of a sexual nature in relation to the person, where the person either is offended, humiliated or intimidated, and a reasonable person would have expected that somebody might be. Okay, so either if you go through your state system or you go through the federal system, you've got a year to make your complaint. So don't think about it. A year can slip by fairly quickly. I think if complainants want to raise concerns, they really should do so as soon as they possibly can, as soon as they feel up to it. There's lots of options for delaying the proceedings once they start, but missing a timeline can be fatal. So it's best to make the claim as soon as you can. Just referenced that there are some longer timelines for different types of claims, but if you want to come through the discrimination channels, 12 months. One of the easiest forms of complaint to make, you've got lots of options. The complainant can fill out a complaint form online. They can download the form and handwrite it if they want to. The commissions will even accept a letter to initiate a complaint. So there's no formality, no insistence on formality in commencing the complaint. The commissions understand that complainants are vulnerable, that they might have difficulties expressing themselves, and they do make allowances for that. The commissions try to assess the complaints quite quickly. This is really significant. Can ask a complainant for more information. That happens regularly. So if a complainant raises concerns about issues that don't quite fit into the box of discrimination or sexual harassment, the commissions will go back to them and say, okay, you've told me A, B and C, but if your complaint is to fit within our jurisdiction, you need to tell me A, B, C, D, E and F. So they can prompt the complainant for more information. which is a good thing for complainants. It can be challenging if you're representing an employer client who can see that the Commission has very strongly prompted a complainant, but I think there does need to be a balance between the two, that a claimant's application can't be rejected just because they haven't been able to express themselves properly. The Commission accepts or rejects the complaint on a preliminary assessment. So look, most complaints are accepted once the claimant's been given the opportunity to clarify. If it's accepted, it moves directly into a conciliation process. The Commission generally schedules a conciliation it's usually within a few weeks once the acceptance is through. The acceptance process can sometimes take a fair number of weeks to work its way through the process, but once it's accepted, it's usually reasonably quick. The employer can reply if they want to, but they don't have to. They can just come along to the conciliation and provide their response. The Commissions use professional conciliators. Always allow at least 3 hours to work your way through a conciliation in the Commissions. If you're acting for a claimant, do put them on notice that they will be expected to participate personally, even if they have a representative sitting next to them. And in fact, the conciliators are trained to ask questions that only the claimant can answer. Now, that's all to do with the philosophy of the Commissions, that they want the claimants to be involved in the settlement and to not let the lawyers run away with the process, or the representatives run away. Process in the conciliation, each party makes an opening statement. The conciliator will ask questions. As I say, the claimant should be expecting to have to answer at least some of those personally. And quite often, if there's an employer representative on the other side, the conciliator will often ask some questions that are tailored, that only the employer can personally respond to them. So just be prepared when you're advising. Parties are then sent into separate rooms, or if it's being done by a phone conference, the phone conference sort of splits off. The conciliators extract offers out of each of the party, or do their best to extract offers out of the parties. If it's settled, really important to write down what's agreed on the day. For whatever reason, I find if you don't write it down on the day, everybody has a different memory of what was agreed, even 24 hours later. So highly recommended, even if you're sitting there handwriting the terms, even just the basic terms of settlement, and get everybody to sign it on the day is very, very important. If it's not settled, the claimant has an option to refer to the Commission for All Workplace Matters, QCAT if it's a non-workplace matter, and to the federal court if the election's been made to take it through the federal system, federal court or federal circuit court. Very, very important to consider at this stage whether a non-publication order is required. So once the matter's referred into the Commission or to a court, it can be subject to media interest. Certainly, many of the sexual harassment complaints have historically been of great interest to the media, and you should assume that if you're in a sexual harassment matter, it will be picked up by the media in one way or another. And if you've got a complainant who's a bit vulnerable, if there are criminal proceedings that are happening either at the same time or might have already been through a criminal process, there are lots of reasons why a non-publication order might be appropriate, and what that means is that all of the parties get de-identified. So all the newspapers can publish is the very general background information. Okay, that's our definitions of sexual harassment and where to go for a complainant. We're now looking at this from the perspective of the employer. So either you're advising a claimant and you need to have regard to what's the defence of the other side going to be, or you're advising an employer. You might be advising, it'd be really nice if you were advising an employer proactively. So an employer comes to you and says, how do we make sure we're protecting ourselves and our workers from sexual harassment liability, or you're advising an employer who's already responding to a complaint. Vicarious liability applies in relation to sexual harassment, and it's the usual form of that. It's the responsibility of an employer for the actions of their workers while they are on the job. So we'll talk a little bit about how far that concept of employers on the job goes. And as you might imagine, it's more than just while they're in the office. The defence that's available to employers is they must take, or the obligation in fact, so it's not really a defence, it's an obligation. They must take reasonable steps to prevent workers or their agents treating others unfairly or badly, or specifically they must take reasonable steps to prevent sexual harassment from occurring in their workplace. So where is this workplace behaviour regulated? Well, it's pretty much everywhere where employees are either together or identifiable as an employee group. So most definitely everything that happens in the office, most definitely everything that happens at work functions. A number of the workplace investigations I've done over the years involve what happens after the end of a work function. And I can certainly say that the obligations do extend beyond the end of a work function. You can't sort of stop being responsible for your employee behaviour at 9 o'clock. Even work-related social events. So things like employees meeting at the bar downstairs underneath their building or next to their building after work. It's not a social club event, it's not a work event, but it is a group of employees. Job seekers are protected, so even if they're not your actual employees yet, they're still protected from workplace harassment, and it actually extends to your recruiters. So recruiters must not sexually harass job applicants. So it's very, very broad. Contractors and agents, it's really just as broad as you can imagine. Social media between employees or referring to co-workers, even if it's outside. And even during the course of private activities if identifiable as an employee. And that's the real shock and surprise for most employers, that if there's an identifiable group of employees who are meeting up together on a weekend, for example, that where they're an identifiable group within the employee area, the employer can still be liable for that. So there's no artificial distinction that because it's not officially sanctioned that the employer is not responsible for it. So what are these reasonable steps that employers must take? This is sort of the general statement: policies, information and training. And I have to specifically say that owners, managers and supervisors, interestingly, I think they should be a separate, have separate training. Part of them are very busy, and